The information contained herein is provided for entertainment and informational purposes only and should not be construed as legal advice on any subject matter. The content of this show contains general information and may not reflect current legal developments, verdicts, or settlements. Any information contained in this show is not intended to be a substitute for legal counsel.
Hello, everybody, and welcome to another Thursday episode of The Family Man. This is Grant Gisondo. I'm the owner of the law offices of Grant Gisondo, PA, a full-service family law firm located in Palm Beach Gardens, Florida. Feel free to call us today for a free in-person consultation regarding any family law case, 561-530-4568, or online at sunshinedivorce.com. We will fight for you each and every step of the way. 561-530-4568. And again, welcome back. If you tuned in last week, we had the wonderful Magistrate Thomas Baker, one of the magistrates at the main branch courthouse in West Palm Beach, talking to us all about child support. If you missed that show, you might want to check us out online so you can hear that show again. All of the shows will be hosted on our website now at sunshinedivorce.com. If you click on the tab that says radio show, you can listen to all of our past episodes, but particularly last week's is not one that you want to miss. Magistrate Thomas Baker, he was here. He spent about 45 minutes with us, spoke all about child support, time sharing, what the court actually wants to hear from a litigant in these type of cases. One of the biggest things that he said was that, of course, magistrates, if you remember, they have exclusive jurisdiction over all family law matters involving child support. One of the few things that you will always end up in front of with a magistrate is child support. So if you find yourself before Magistrate Baker, tell him you heard him on the radio, tell him we said hello. We're very thankful that he was here with us last week. Today we're going to talk a little bit more about child support, again, breaking down this statute, everything that you need to know. A lot of questions that have been coming up these past 2 weeks for child support has been, okay, so I've gotten through the child support statute, I've gotten child support done. Now one party is no longer honoring the time-sharing schedule that we signed off on. What happens now? Well, there's actually a couple things that the court can do. And of course, the court can only do something if you file a proper motion. Okay, so what you need to do is basically, if let's say your spouse or your ex-spouse is not letting you see your children, one thing that everybody needs to know, and everybody gets this confused, your payment or receiving of child support has nothing to do with you seeing your child as far as enforcement goes, which means that if your husband or wife was supposed to pay you $500 in child support on the first of the month and they didn't do it, you do not now get to say, well, you don't get to see your child. One is not contingent upon the other. Yes, they are related when calculating child support, but when it comes to enforcement of child support and time sharing, you cannot combine the two. Remember, your child needs to see their parent, the mother or father, for their needs. You need child support to satisfy the financial needs of the child. They're two completely separate things. Please don't confuse them. The worst thing you could ever do is say, well, I'm not letting my ex-husband see the child because he didn't pay me child support, or I'm not letting the child's mother see the child because she didn't pay me child support. Don't do that. The punishment, you will be in contempt of court every day of the week. It is completely wrong, and it is the worst thing that you could possibly do for your child. Let's think about this practically for a moment here. Your child wants to know why they're not going to get to see their father for their Wednesday through Sunday time sharing. And what are you going to tell your child? Well, he didn't pay the child support, so you can't see him. You should absolutely not tell your child anything about child support. Remember, another huge thing. Do not badmouth the other parent in front of your child. You're making your child have an interest or a care about the case and the differences you have. Psychologically, that is completely the worst thing you can do. Please, everybody, don't do that. So getting back to the statute here, basically, even if you're not getting child support, you may not refuse to honor the time-sharing schedule between the parents. And if you do, let's say you've done it. Let's say it's happened. Oh, Grant, I didn't hear your show. I didn't know. He didn't pay child support. I didn't let him have his weekend. Now what? Am I doomed? Am I going for contempt of court? What's going to happen? It's very simple. Just offer him makeup time. Give him the next 2 weekends. Give him the next 3 weekends. However long that you improperly withheld the child for, give him an opportunity to make it up. Okay? Give him that time to basically make up the missed days, just like in school. You miss a day at school, you got to make that day up. It's the same thing with the time-sharing schedule, except you're adults. You're not in school. Thank God. Anyway, so that's the first thing that the court can also do if you miss your time sharing is the court can order you to have make-up time sharing. Now, if it's done with a court order, it's very different. You've already been in front of the judge. You've already been in front of the magistrate. They've already said, okay, well, I'm going to order make-up time sharing. But let's say you do it again. Or let's say the court feels like you've done it for so long. Let's say you've done it for 6 months. 6 months, you've refused any time sharing because you haven't been getting child support. What else can the court do? The court can also, aside from make-up time, offer additional time. So let's say that the time that needs to be made up is 10 days. Well, the court wants to punish you because you've withheld the child for, let's say, the past 10 days. The court has the power to basically say, well, instead of giving 10 days, we're going to give 20 days, or we're going to give the next month. What does this do? It kind of teaches you a lesson. It teaches you the hard way that you really can't institute self-help with the courts. If you have a problem with not getting child support, hire a family law attorney, let them file the proper motion and bring the issue before the court. If your spouse or your ex-spouse, your girlfriend, your mother, whoever it is not letting you see your child, don't resort to self-help. Don't take the matter into your own hands. That's the worst thing you can do. Hire an experienced family law attorney like us at Grant Gisondo, PA. We will file the proper motion with the court. We will bring you before the judge, and we'll let the judge make the decision on what's going to happen. Self-help is severely frowned upon in Palm Beach County as well as in all the courts in Florida. So make sure you're calling your family law attorneys to help you in this matter. Now, let's say it's happened. You're before the court. You don't know what to do at this point. You've been denied time sharing or you're denying time sharing. The person who's basically wrong in the situation, who would be the person that's either not paying the child support or the person who is wrongfully withholding a child, can be responsible to pay the other person's court costs as well as attorney's fees. So let me give you an example here so you understand what I'm talking about. So what I'm saying is that let's say you come and you hire me at the law offices of Grant Gisondo, right? You come in, we have our free in-person consultation. We sit down for a half hour and you say, hey, my former wife is not letting me see my kids and I am paying my child support obligation. Well, I'm going to file a motion to enforce your final judgment to get you to see your kids. And then once that happens, when we go before the court, I'm going to ask the court to order your ex to make her pay your attorney's fees for being forced to hire me and represent you in this matter. She did something wrong. She didn't let you see your children. As such, you had to hire an attorney. You couldn't use self-help. You had to bring the issue before the court, and now we have a judgment. And part of that judgment is going to be her paying your attorney's fees. Another reason to have a family law, have a licensed attorney represent you. Only attorneys can collect attorney's fees. If, let's say, you decide you want to represent yourself, you can't go in front of the court and ask for attorney's fees because you're not an attorney. Not too confusing there, not too simple. So if you're just tuning in, we're talking a little bit more today about child support, time sharing with the child, or custody, as a lot of people call it. We're going through what happens if your spouse is not letting you see your child and you are properly paying child support. One of the things that we also mentioned is don't resort to self-help for any reason. And again, this is all included in the child support statute. Just giving you some information that you may need to know for everyday life. And again, if you're just tuning in, this is Grant Gisondo, the family man. I'm the owner of the law offices of Grant Gisondo, PA, a full-service family law firm located in Palm Beach Gardens, Florida. Feel free to call me today for a free in-person consultation for any family law case, 561-530-4568, or online at sunshinedivorce.com. If you're too busy to visit the website or you're too busy to sit down and make a phone call, shoot me an email when you get a few moments, grant@sunshinedivorce.com. Okay, so like I said, the court can order some makeup time. The court can also order the offending spouse pay reasonable court costs and attorney's fees. And let me focus in on that for just one more minute here. It's reasonable attorney's fees. If you show up to one hearing and you filed a motion, one motion, and you showed up to a 30-minute hearing and you're asking for $25,000 of attorney's fees, pretty sure that's not reasonable. The court wants there to be a reasonableness when dealing and fairness when dealing with one another. What is considered a reasonable number? I don't know because there isn't one. The courts don't give us what exactly a reasonable number is, but most attorneys we like to use good judgment. We don't like to overcharge, and we don't also want to penalize people to the point where they can't actually pay the fees. We want the fees to be somewhat of a penalty, understand, to make our client whole again for having to file this motion. We don't want it to be essentially a punishment where, let's say you get into a car accident and you have to pay $100,000 of damages because you were driving while intoxicated. That's not this type of situation at all. Okay, so moving along, what else can the court do? The court can also order the offending spouse to attend a parenting course. Now, if you've gone through a dissolution of marriage or a divorce, as a lot of people like to call them, you've probably already gone to a parenting course. There's two ways to do those things. You could do them online, sit in front of your computer from anywhere from 2 to 5 hours, depending on the course that you choose, or you can go in person. They're usually done a couple nights a week or on the weekends. It's about 3 or 4 hours, and you walk away with a certificate. So basically, the court can make you do this again and say, hey, you didn't really get what we were trying to say about co-parenting the first time. So we're going to make you do it again. And the court can make you do it again and again and again in order to drive their point home. Co-parenting is so important. You need to figure out how you're going to get along with the other person. The other parent to your child. You need to figure out how you're going to make some concessions and how you're going to kind of work things out, and you're going to raise this child. Remember, the child didn't ask for two people that are fighting, that aren't together, that can't get along. What the child needs is a loving environment that they can thrive and they can feel loved and they can basically start their life feeling whole. When you start fighting and you start putting the child in the middle of the situation is when the child is going to start to develop psychological problems, behavioral problems, the grades might slip, things that you want to watch out for. You don't want to do that. So that's what the court can do as far as a parenting class. Now, this has only happened once in my career where I've seen this. So if, let's say, they've ordered the makeup time, let's say you're already paying attorney's fees, or let's say that you've already been ordered to attend a parenting class and you're still not getting it. And remember, this is all stuff the court could do, not stuff the court has to do. This is all the court may do, these following things. So the other thing the court can do is they can order you to conduct some community service. What is community service? No, it is not hard labor. No, we're not asking you to build bricks or move anything along the lines. But what can they do? They can ask you to volunteer at a church. They can ask you to paint a church. They can ask you to sweep up around a church. They can have you attend a local community center and have you clean the floors of the gymnasium for community service. There are certain community service organizations that actually specialize in doing this. Again, this isn't something I frequently see. In my career, I've only seen this once. I didn't request it. Actually, the court came up with it on their own regard. I believe in that specific instance, the person was to volunteer 15 hours of their time on a Saturday to a homeless shelter where they were helping clothe and feed people. That was kind of the end of that case. I know that they did do it because we did file a compliance with the court. And you know what? The person never violated their parenting plan again. So that's a good message. It got through to the person, which is overall the point of the court's things. So, okay, other than community service, what else can we do? Well, you can make the financial burden of promoting frequent and continuing contact with the child on the offending parent. Now, that's a bunch of big words. So what does that mean? I'm going to tell you what that means. Okay, so basically, let's say that you are to pick up your child on Fridays, and then your ex is to pick the child back up on Sundays. The court can now make you responsible for both pickups and drop-offs. How is that a financial burden on you? Well, you have to pay gas. You have to pay gas both ways, pickup and drop-off, and tolls if they're applicable. Or let's say that you're communicating with your child via FaceTime. Well, you're now paying for that cell phone. So there's different financial things that they can put on you to show their seriousness and to make you comply with this. Now, the final thing, and this is the most severe thing that I've ever seen, let's say that you sign a parenting plan and a settlement agreement with your spouse. Everything is all said and done. And let's say that you are to see your child for, and again, this is completely random just for simplicity purposes, you're supposed to see your child for 7 days in a row, and then your spouse for 7 days, and then you for 7 days, and then your spouse for 7 days. So in a month, it's every other week. Very rarely do I see a week on, week off, but it's simple, so that's what we're talking about today. The court is if you are continuing to offend or you're the offending parent, depending on the level of offense that you've made to the parenting plan, the court can actually modify that parenting plan as a sanction to you. So where you would have had 50% time sharing with the child. Now you're down to 30% of time sharing. How they're going to do that, we're going to say that you no longer have week on, week off. You're now only going to see the kids Friday, Saturday, and Sunday. That's it every other week. So you went from having 15 overnights down to about 10 overnights. They've took away 5 overnights for you. Is that a severe penalty? In my opinion, yes, it is. Does the court do this? Yes, they do. If you're constantly offending or you're constantly violating the agreement that you signed with the parenting plan, you're denying access to the child, you're interfering with the other parent's phone calls with the child, or you're just not doing what you should be doing under the agreement that you signed or the agreement that the court ordered you to follow in a trial setting, they can modify it and take away your time. They do this a lot. The court is also given some free rein under the statute that they can impose any reasonable sanction as a result of non-compliance. What is any non-reasonable sanction? Well, it's not exactly clear. I think we've kind of covered the most common ones. Typically, what I see on a daily basis, extra time sharing is ordered. Typically, attorney's fees and costs are ordered. Community service, not so much. The financial burden, every once in a while, maybe 30% of the time. A modification of a parenting plan. If you violated your parenting plan 3 or 4 times, you're getting modified. The courts are really coming down on people about this stuff. So it's a risk, especially if you have a parenting plan that you really negotiated where you get 50-50 time sharing, or you went and had a 2-day trial and you've spent a bunch of money on attorneys and experts, and you've spent 2 days trying the case to show that you have equal time sharing with your spouse. To get that modified because you're not following the plan is really foolish. I mean, it's just a complete waste of money. So basically, if you're going to sign an agreement, stick to it. If you went to trial and you got an order, follow that order to the T. Those orders are not negotiable. They're not guidelines. They are rules. They're orders. They're telling you exactly what to do. If you guys are just tuning in, this is Grant Gisondo, the family man, the owner of the law offices of Grant Gisondo, PA, a full-service family law firm located in Palm Beach Gardens, Florida. You can call me today for a free in-person consultation for any family law case, 561-530-4568. Shoot me an email, grant@sunshinedivorce.com, or visit our website, www.sunshinedivorce.com. We'll be right back.
Non-attorney spokesperson.
Without the proper training, diffusing a highly volatile bomb is not something you want to try by yourself. When a marriage is about to explode, the same wisdom applies. Hire a professional or pay the consequence.
Headed for divorce? Diffuse the matter with the guidance of the law offices of Grant Gisondo. Online at sunshindivOrce.com. That's sunshindivOrce.com. Main office in Palm Beach Gardens.
Welcome back, everybody. This is Grant Gisondo, the family man. If you're just tuning in, today we are talking about child support, time sharing, and parenting plans. I'm the owner of the law offices of Grant Gisondo, PA. We are a full-service, cradle-to-grave family law firm located in Palm Beach Gardens, Florida. Feel free to call me personally anytime for a 100% free in-person consultation, 561-530-4568, or online at sunshindivOrce.com. We will fight for you each step of the way, 561-530-4568. Okay, folks, going a little bit further now into the child support statute. We've actually finished the child support statute. It took 2 shows, but we got it done. You guys now know absolutely everything there is to know about time sharing with a minor child, child support with a minor child, but now I'm actually going to take you through a parenting plan. What is a parenting plan? It's an interesting question. A parenting plan is actually something that is developed in your dissolution of marriage case or in your custody case, in your paternity case, that basically gives the specifics of the day-to-day responsibilities of each parent. Is this done in every single case? Yes, it is. If you're getting divorced and you have minor children, this is required. It's not just, oh, don't worry, we'll figure it out, Judge. Me and my ex can figure out when we're going to see the child and how all that's going to work. No, you're not. We're going to write it down for you. You're both going to sign it, or the judge is going to order it. A parenting plan is required in the state of Florida for every dissolution of marriage case where there are minor children. It is also required in every single case involving custody. Okay, so let's talk a little bit about a parenting plan. You know what a parenting plan basically is? It's actually a written plan. It's about 15 pages long. Am I going to go through every single detail of this plan? No, I'm not, because you're going to be asleep. I'm going to be asleep, but we're going to go through the greatest hits here. So basically, I have a parenting plan in front of me. It's one that we use pretty generally. It's a starting point. Remember, if there's specific parts of your parenting plan, or there's specific parts that are really important to you that you need in a parenting plan, call me. We can work that out. We can build that into a parenting plan. If there's portions that you need, or like, let's say, for example, you don't want your mother-in-law to ever be around your minor children for whatever reason, and you better have good reason, by the way. You can't just say, hey, I don't want them around, I'm the dad, and that's the way it's going to go. It doesn't work like that. You need really good cause for something like that. But if you feel like you have good cause and you want to talk that out and you want to get that into a parenting plan, it's possible. These parenting plans are written specifically for your situation, for your family, for your children. It's not like, hey, this is a parenting plan for the state of Florida, so this is going to work in every single case. No, it doesn't. We're just going over some of the general ideas here. So obviously, one of the things that the parenting plan has to have in it is the parents' names, mom's name, father's name, full addresses, contact information for both of you. This address is important because this is where we're going to assume the child is living when the child is with you, or the child is when the child is not with you. One of the big things in Florida is you have to always know where your children are. You have a right to always know where your children are. So for example, if let's say your ex says, I no longer want you to know where I live, well, then the child is not going there until you have that address. You have a duty to be informed. The next thing, not rocket science here, folks. What else needs to be included in this parenting plan? Well, the children's names and the children's date of birth. But do we actually put a minor child's full name in a parenting plan? No, we don't. Remember, the court and attorneys, we're here to protect your children. So we only use the children's initials. Therefore, the children are not specifically identifiable in these. So let's say that your child's name is Billy Bad Boy. The initials are going to be BB, and we're going to put in the child's date of birth. Let's say that's July 2004. That's going to be included in the parenting plan. There's going to be a little statement about jurisdiction, basically saying that the United States is the residence of the child. The state of Florida, for the purposes of the home state, is included in here, and the parenting plan is necessary under the jurisdiction of the court. Next thing, and this is something that we litigate very, very frequently, is parental responsibility and decision making. 9 out of 10 people that come into my office for a consultation, when they fill out the initial forms to meet with me, they say that they want sole decision making. They don't want the other parent to play any role whatsoever in the decision making for the child. That's number one. The second thing is they want shared parental responsibility, but they want ultimate decision making authority. How often does this happen? Maybe 20% of the time. Typically, 90% of the time, shared parental responsibility. Now, what is shared parental responsibility? It is based on the best interests of the children that the parents confer and jointly make all major decisions affecting the welfare of the child or the children. These major decisions include decisions about the children's education, the children's health care, and other responsibilities unique to the family. So what does this basically mean? It means that if you're going to enroll your child in a school, both parents have to play a role in that. They have to jointly make that decision. If you guys can't agree, then you need to go to either mediation or you need to litigate those issues in court. But folks, we're talking about school here. This is really important. You want to be able to work this out with your spouse. If you can't figure out what kindergarten your child is going to go to, how are you ever going to figure out what high school your child is going to go to? And the other responsibilities that you're going to have as a parent. There has to be communication between the parties. How does this differ from shared parental responsibility with decision-making authority? Well, basically, with decision-making authority, you jointly confer. And after you guys confer, let's say that dad has decision-making authority. Dad's going to say, well, look, I appreciate your opinion. I'm overruling it. This is where the child's going to school. And that's decision-making authority. Basically, one person gets to make the decision on their own after hearing some information from the other parent. Is it fair? Usually not. Is it something the court orders? Sometimes, rarely. Why does a court order that? A court orders that where basically if you have a history of making really bad decisions, if you're unavailable to make decisions, or you've made decisions to hurt the parent, which in a way are affecting the welfare of the children, not something you want to do. And of course, what is sole decision-making authority or sole parental responsibility? It means you can do whatever you want and the other parent has nothing to say about it. If you want to enroll your child in, let's say, Jupiter High School, and the other parent is opposed to it, doesn't matter. Doesn't matter what they say. They don't even get to say anything. You get to just do what you want. You want your child to go there, they go there. You want your child to be in gymnastics, enroll them in gymnastics. You want them to play baseball, enroll them in baseball. You're basically cutting out the other parent from your child's life completely. Is that something that happens frequently? Nope. No, it really isn't. One of the things you can almost, and strengthen the word almost as much as possible in this situation, you could almost guarantee that the parties are going to have shared parental responsibility in a case, unless that person is incarcerated, has a drug problem, has an alcohol problem, or some other factors are contributing to basically show that they cannot make a decision. Again, all those decisions, parental responsibility and stuff, they're all based on the best interest of the child. So you would have to show that the other parent having some say in decisions affecting the child would not be in the best interest of the child. So again, if you're just tuning in, this is Grant Gisondo, the family man. We're talking a little bit more about a parenting plan today, actually taking you guys through a parenting plan, a requirement for any dissolution of marriage case when there are minor children, or a custody case, or a paternity case, or a maternity case. These have to be filed in every case. So the other thing that this is going to talk about, and things that are highly overlooked by people when they're trying to make decisions, are extracurricular activities. And how's that going to work? For example, let's say that your child goes to West Palm Beach High School, and let's say that at high school your child wants to be enrolled in football. Well, your child needs a helmet, he needs pads, he needs cleats, he needs sneakers, he needs all this stuff. How are you going to pay for that? That actually is not covered by child support. So in this agreement, we're going to say who can register the child for extracurricular activities. Do the parents need to mutually agree on extracurricular activities? If they don't need to mutually agree, then who makes that decision? All stuff that's negotiated. Typically what happens is the costs for extracurricular activities are shared by the parties, meaning mom pays 50% and dad pays 50%. Uniforms and equipment also split 50-50 in most cases. When does 50-50 not occur? Well, if mom or dad is making a substantial amount of more money than the other parent, and the other parent just can't afford to pay for anything, well, then they're not going to be required to pay for much. Sometimes it can be broken down in percentages where mom pays 80% and dad pays 20%. It really depends on what you can afford. But again, these are the costs of raising a child. Don't tell me that you can't split a $50 football helmet $25 a piece. Work an extra shift. Don't buy a six-pack that week. Pay for your children's helmet if he needs one. Very simple. We want you to be involved. We want you to go to those games. Now, here's a little game that people play, and this game drives me absolutely crazy. So let's say that the parties agree that the child can be enrolled in baseball, and every single baseball practice falls on mom's timesharing. So mom, when she's supposed to be enjoying time with the child, all she's doing is taking the child to baseball practice and then bringing the child home from baseball practice. And the next day, baseball, back home from baseball practice. Don't enroll your child in an extracurricular activity that is going to severely impact the other person's time sharing. This is a no-no. Now, will it interfere on both parties' time sharing? Yes, of course it will. They're after-school activities. Someone has to bring them there. Someone has to bring them home. But if you're doing it purposely just to interfere with the other person's time sharing, you're going to have a serious problem in court. So what I typically do is I tell the parties, look, get together. If you both agree that your child can be enrolled in baseball, understand that baseball practices are going to happen Monday, Wednesday, Friday. It's going to interfere in mom's time. It's going to interfere with dad's time, and you're both agreeing for that to occur, and that you're going to split the costs of attending, of playing baseball with school evenly. For example, cleats, split it evenly. Pads, split it evenly. A baseball glove, bat, balls, things like that. Simple things. You should be able to split those evenly. If you can't, or for some reason you feel like you shouldn't, then this is really when you want to sit down and bring this up at a consultation when you sit down and meet with me. Okay, continuing on with a parenting plan. And if you're just tuning in, this is Grant Gisondo, the family man, the owner of the law offices of Grant Gisondo, PA, a full-service family law firm located in Palm Beach Gardens, Florida. Call me today for a free in-person consultation regarding any family law case, 561-530-4568, or online at sunshinedivorce.com. We will fight for you each and every step of the way. 561-530-4568. Since I have a lot of people tuning in right now, I do want to let you know that if you have any questions about anything that I'm saying on these shows, or there's a subject that you would like to hear me cover, or you just want to have a conversation with me, give me a call. It's fine. This is why I'm here. 561-530-4568. If you don't want to have a long conversation and you just want to drop me an email, that's totally fine too. Grant@sunshinedivorce.com. Questions, comments, concern, future topics, anything you want to hear, send them over. Okay, so we're continuing on with our parenting plan here. The next thing that we're going to talk about here is the school calendar. What school calendar is your child going to follow, whether it be Palm Beach County, Martin County, Broward County, Miami-Dade County? That does need to be specified in the parenting plan. Obviously, if both parties live in Palm Beach County, your child's lived their whole life in Palm Beach County, we're not going to change this to Broward County. We're going to keep it Palm Beach County. Remember, for your children, we want there to be consistencies every single year. You don't want your child going to different schools every single year. You want them to be as consistent and stable as possible. So one of the things that we also put in here is scheduling changes. Let's say that you're supposed to have your child this upcoming Friday, Saturday, Sunday, but let's say you just can't do it. You have a work trip. You have another child that has a function that you need to get to. You need to go to a wedding. You need to go to a birthday party. There's a million reasons why you would need a scheduling change. We want to put it in here that scheduling changes, of course, are permitted. You have to give the other parent, though, so much notice. How much notice do you need to give? Well, there's really no rule on this. I typically tell people as soon as you know, tell the other party, but really, I want at least 7 days. I want 14 days. If you're going to a wedding, for example, typically wedding invitations are sent months in advance. Let the other parent know, hey, I'm not going to be able to do my time sharing this weekend because I have this wedding to go to. So as much time as possible. I like a minimum of 5 to 7 days. Okay, now we're getting to the most important part of this parenting plan, and this is the actual time sharing schedule. This makes or breaks every single parenting plan. You know, a time sharing schedule that's improperly written leads to more questions than it does answers. People aren't going to know the time they're supposed to be picking up their child. For example, I read a parenting plan one time that said the father's time sharing begins on Wednesday after school. Well, that parenting plan was implemented when the child was in kindergarten, and the child ended school at that time at 1 o'clock in the afternoon. Well, now I'm reading the parenting plan, and the child doesn't get out of school after extracurricular activities to 7 o'clock at night. So the dad doesn't know, am I supposed to be picking up the child at 1:30? Am I supposed to be picking up the child directly after school? Am I supposed to be picking up the child after the extracurricular activities? It leads to too many questions. Why? Because your parenting plan wasn't written with sufficient specificity to lead you to having no questions. And you shouldn't have any questions regarding your responsibilities as to when you're supposed to pick up the child. We very, very specifically write these for your situation. So, for example, if you were to pick up your child on Sunday night, let's say that Sunday night time sharing is ending and you're going to go pick up your child Sunday night. My parenting plan is going to say that and I like the person who's beginning their time sharing to do the pickups. One, it gives them motivation to be on time. If you haven't seen your child for 4 or 5 days or 3 days or 2 days for that matter, and you know that your time sharing is going to begin on Sunday, you're going to be pretty anxious to get there. You're going to make sure you get on time. Whereas the parent who's ending their time sharing doesn't really have a lot of motivation to get the child back to you on time since they want to enjoy every minute they can with the child. So back to our example, let's say that you're supposed to pick up your child at Sunday. You're supposed to pick up your child Sunday. When? So in my parenting plans, I actually write the child time sharing is to begin Sunday at 4 o'clock. Child is not to be picked up any later than 4:30 without a phone call or a text message. What does that do? It tells the person that they're going to be picking up the child at a specified location. And yes, it's going to say exactly where you pick up the child every single week at 4 o'clock on a Sunday afternoon. If you're going to be late, you have to contact the other person by either telephone or text message saying, hey, I'm running late. And if after 4:30, if you don't show up to pick up your child, guess what happens? You waive your time sharing. You don't show up for your kid on time. You show up at 7 o'clock at night without a good excuse. You don't get to see your child. Does this happen? Come on, Grant. Does this happen? People say to me all day long, do I really need that type of specificity in my agreement? Is it really necessary? Yes, it is necessary 100% of the time, every day of the week. Because the one time that you get a flat tire and you don't show up and you don't contact your ex is not going to want to let you see the child for that night. And then you're going to end up back in litigation for absolutely no reason. All you have to do is pick up your phone, send a text, say, got a flat tire. We'll get there as soon as I can. Should be there in an hour. Keep communicating with the other parent. No problem. Okay, we're going to continue talking about this timesharing schedule and the importance of it when we come right back after a really quick commercial break.
Non-attorney spokesperson.
Without the proper training, diffusing a highly volatile bomb is not something you want to try by yourself. When a marriage is about to explode, the same wisdom applies. Hire a professional or pay the consequence.
Headed for divorce? Diffuse the matter with the guidance of the law offices of Grant Gisondo. Online at sunshinedivorce.com. That's sunshinedivorce.com. Main office in Palm Beach Gardens.
Welcome back, everybody. This is Grant Gisondo, the Family Man. I'm the owner of the law offices of Grant Gisondo, PA, a full-service family law firm located in Palm Beach Gardens, Florida, covering all of Martin County, Palm Beach County, Broward County, and Miami-Dade County. Call me today for a free in-person consultation regarding any family law case, 561-530-4568, or online at sunshinedivorce.com. We will fight for you each and every step of the way. 561-530-4568. Today we're doing a great show here for you about timesharing. We're specifically talking about a parenting plan. But, I'm constantly saying, folks, if you have questions, if you have topics that you want to hear, or there's stuff that you want to know, shoot me an email. The response has been great, and I'm honored that you guys are listening and that you're participating and actually sending me questions, because these questions are great. So what I'm going to do here, folks, is I'm actually going to finish this parenting plan on next week's show. So we just finished talking about the time-sharing schedule. So if you want to tune back, you can hear about the time-sharing schedule, about who's doing what every day of the week and how they're doing it and what times, and the importance of being specific in these things, stuff that really an experienced family law attorney can do for you. So we're going to get to that in a minute, because I want to get to some questions here. And these questions are excellent, and it really shows that you guys are not only understanding everything that I'm saying, but you're involved and you're coming up with some real life examples. So thank you for sending me these in. Keep sending them in. If you have a question, Grant at sunshinedivorce.com. Just put it in the message, in the heading, radio show question. You can stay anonymous. If you want me to read your name, tell me you want me to read your name. If you want to stay anonymous, just write anonymous. And don't worry, I will not say your name on air unless you want me to. So we got some questions here. Let's get into them. Cynthia from Boynton Beach. Thanks a lot for writing me today. I love your show. Thank you, Cynthia. I love doing the show. You've said that in Florida, having a child overnight is the only way that day counts toward child support and other factors. Do other states do it differently? Well, Cynthia, to be completely honest, I have no idea, because I am only licensed to practice law in the state of Florida as well as Washington, D.C. I don't know what other states do. I do know that some of the northern states, New York and New Jersey, they make you actually pay child support through college. They can also make you pay some of college expenses. But here in Florida, we don't do that. Here in Florida, child support stops when you're 18. Here in Florida, the only thing that matters when calculating child support is overnights. So if you would like to give me a call, 561-530-4568, Cynthia, we could talk about specifically what state you want. And I have other attorneys that I work with in other states. I can always refer you to them, and they can give you much more of a specific answer. So the next question that we have here, Robert from Hobe Sound. My ex-wife wants our daughter to go to a private university that I cannot afford. What do I say Do I have a say as to where she goes to school? Yes, Robert, you absolutely have a say, assuming that you have shared parental responsibility, which is a subject we just covered moments ago. Remember, shared parental responsibility is that you have to confer and jointly make all decisions. If you cannot afford your child to go to a private school, then that's something that would fall into the shared parental responsibility. But now, Robert, you put an interesting word in here, and that word is university. In Florida, like I just said, you have no obligation to pay for your child's college education. If you want to go on my website, sunshinedivorce.com, or gisondolaw.com, that's GISONDOLAW.com. I actually wrote a blog about ethical responsibilities versus legal responsibilities. Do you have an ethical responsibility to pay for your child's college education? I'm not going to answer that question. That's based on your personal convictions and your choice, but read that blog. It'll point you in the right direction. So can your ex force you to pay for a private university, meaning college? No, because there is no legal responsibility to pay for college in Florida. A private grade school, depends if you had shared parental responsibility or not. Robert, give me a call if you have any questions, but I would say overall, no, she really can't do that, assuming you have shared parental responsibility. Lawrence, Mr. Lowry from Delray Beach, sent in this question. I'm not married, but everyone seems to think that a man in the relationship tends to get the short end of the stick when it comes to child support and custody. As someone who deals with it every day, do you feel that this is true? Lawrence, great question. This is actually a stereotype that I do deal with every day, multiple times a day, multiple times an hour. No, I don't think that's true. I would probably say 50% men, 50% women. I've never felt that I've had the upper hand by representing a wife or a woman or the mother. I've also never been in a situation where I felt that the court made the incorrect decision strictly because my client was a man. Those old days of family law, I like to call them the Wild West, when there weren't really many rules that applied, where the wife automatically gets the kids or the mom already gets the kids. No, that's gone. In fact, most of the courts today, they want the father, the husband, in the child's life as much as possible, especially if you want to be in a child's life. Remember that there's plenty of people out there that unfortunately they just don't want to be in their child's life. So when you have a guy coming to the court saying, hey, I just want to see my kid, I want to be with my kid as much as possible, the courts are going to commend that and they're going to let you do that. One of the things that we can go over specifically, the specificities for your case, but no, those days are gone. It doesn't work like that anymore. So no, there is no upper hand. Both parties are 100% equal coming into these cases. Next question coming from Davie, Florida. Mr. Fred. Fred, you talk a lot about divorce, child support, and other topics, but what are some of the things that come up in family law that a lot of people wouldn't realize? Interesting question. So kind of an open-ended question here, but I'll try to answer it the best you can based on what's off the top of my head here. Things that don't come up. One, do you need therapy? Going through a divorce can be a very traumatic event. At my law office, we really try to get you from where you are to where you need to be as quickly as possible, as efficiently as possible, and with the least amount of stress as possible. One thing people need to understand, though, is I'm an attorney. Number one, I'm not a priest, so confessing all of your sins to me is doing absolutely nothing, and I tell people that all day long. But the second thing is I am not a mental health professional. I am not a psychologist. I know probably one of the best psychologists in the United States that I can refer you to. He actually also happens to be my father. Do you need a therapist? You might. If you're going through a lot of emotional problems, you might need a mental health professional to talk you through them. If you're trying to decide whether or not to get a divorce, you might need a mental health professional to help you work through those problems and questions. That's not something I can help you with, but I can certainly point you in the right direction. I also recommend that you meet with a family law attorney before you go see a psychologist. Why? Because a lot of times your attorney and your doctor can work together to set up your case for success. If there's things that you're doing that are not advisable, I'd like to know early in the case so we can correct those actions as quickly as possible. Also, another topic that's been coming up regarding divorces that it seems to be a hot topic is that once the case is filed and the parties are getting divorced, it doesn't mean that you get to stop paying the marital bills. So for example, if you guys have decided you're going to get a divorce and you have a mortgage, don't stop paying your mortgage, guys. You're just going to end up in foreclosure. And then there's nothing we can do. You're losing that asset. So if your husband is typically paying 100% of the mortgage, then he needs to continue paying 100% of the mortgage. If your wife is typically paying for the family's health insurance, then your wife needs to continue paying for the children or for the family's health insurance. And when I say the family, I don't mean just the kids. I mean, if on your health insurance policy that your wife is paying includes dad, child 1, and child 2, all of those policies need to be maintained. A status quo needs to be maintained pending the final result of the divorce. You don't want to be cutting anybody off. You can't cut off someone's cell phone, folks. You got to leave their cell phones turned on. You have to pay their car insurance. Basically, just don't change anything. That's something that comes up regularly. More and more now, what we're seeing is we're starting to employ a lot of forensic experts, for example, forensic psychologists that can give the court an opinion about the best interest of the child and how that's actually going to be served. Forensic accountants, CPAs, if you feel that the other party's hiding money, we can capture and we can find that money through forensic accountant. But Fred, if there's something specific that I'm missing here that you want to know about, give me a call. I'm happy to talk to you, about your case specific if you have questions. 561-530-4568. The next question from Port Salerno, Sophia. Great name, Sophia. I love it. My husband and I have been headed for a divorce but haven't sat down to talk about the next step. What documents, records should I have in order to make sure that I'm ready to begin this process to have a leg up? Well, Sophia, there really isn't such a thing as a leg up, but there are certain documents that we're going to want you to have. It's a really long list. It's not a list that you need to be afraid of by any means. It's stuff that you can probably take care of online in about 2 hours. Give me a call about that, though, because, there's certain things you may have or may not have. Things that I definitely want to see. Tax returns, your last 3 years of tax returns, credit card bills, your mortgage payment, if you have any assets, retirement accounts, things like that, all stuff that I'd like to see. But do you need that for your first consultation, your free in-person consultation with me? No, you don't. Just come. If nothing's been filed, you don't need to bring anything with you. Just come and be ready to talk. One thing that I do recommend that people do is if you're going to be having a consultation with me and you have questions that you need to ask, sit down for 15 or 20 minutes and write those questions down. That way when we finish the consultation, I can make sure that all of your questions are answered. The last thing that I want to happen is for our meeting to come to an end. You're in your car, you're driving home with all the information I just gave you, and it pops in your head, oh, I forgot to ask him about this. What to do in that situation? Very simple. Just give me a call. I'll be happy to talk to you about it. But try to get them all down because we want to make sure you're leaving with all the information that you can possibly have. And we want to make sure that I'm answering all of your questions. So if there's specific things, just write them down and bring them on in with you. Again, if you're just tuning in, this is Grant Gisondo, the family man, the owner of the law offices of Grant Gisondo, PA, a full-service family law firm located in Palm Beach Gardens, Florida. Call me today for a free in-person consultation regarding any family law case. 561-530-4568 or online at sunshinedivorce.com because nobody can spell GisondoLaw.com. But if you want to try, it's GISONDOLAW.com. I got time for one more question today. The last question, Clark from Singer Island. My wife has custody of our daughter during the week, and I have weekends. I'm worried about some of the people she might be letting in my daughter's life to hang out with her when I'm not around. Is there anything I can do? Yes, there's a lot you can do. Remember, everything is based on the best interest of your daughter. If your ex is letting people in your daughter's life, which are questionable, you have a duty to protect your daughter's best interests. Now, it depends on why you think that they're questionable people or what they've done or what you know about them, and as well as how you know this information. This is something you'll definitely, Clark, you'll want to call me about. You'll want to come in, sit down with me. It's totally free. Tell me about what your concerns are, and let's go through some different options on how we can help you. Everybody, I'd like to thank you all very, very much for the questions. Again, if you have any questions, concerns, or topics you'd like to see covered, shoot me an email, grant@sunshinedivorce.com. I'd like to thank you very much for tuning in this week. Next week, we're going to be talking a little bit more about parenting plans. We're going to finish those parenting plans that we started today. Hope everyone has a wonderful week. Remember, be kind to each other. This is Grant Gisondo, the family man. We'll see you next week.
Non-attorney spokesperson.
Without the proper training, Diffusing a highly volatile bomb is not something you want to try by yourself. When a marriage is about to explode, the same wisdom applies. Hire a professional or pay the consequence.
Headed for divorce? Diffuse the matter with the guidance of the law offices of Grant Gisondo. Online at sunshinedivorce.com. That's sunshinedivorce.com. Main office in Palm Beach Gardens.